I shall now hand it over to Mr. Puri to introduce the other speakers.
Thank you. Good morning, everyone. It is my privilege to welcome you all to the conference and today's discussion on recent trends in IP litigation. IP litigation are all about, breaking barriers, much like today's panel. Strong and vibrant women leading the discussion, and yours truly trying to keep up as the moderator. To start with, let me take this opportunity to invite my speakers. I would invite Lakshmi Devi Somnath. She's a partner and litigation at Anand & Anand, has more than 23 years of experience in IP law. She has served as a member judge in the IPAB, contributing to landmark decisions. Her expertise includes high-stake cases, IP advisory, audits, valuation, and corporate IP strategy. Today, she will shed lights on recent trends and challenges in trademark litigation. We have Udita Patro. She is a partner at Anand & Anand, specializing in IP litigation and resolution, with expertise in trademark, copyright, patents, and anti-counterfeiting. She has successfully represented major pharma and luxury brands in India, including winning key IP infringement cases. Udita has co-authored legal guides and regularly conducts IPR webinars. Today, she will provide valuable insights into development and notable cases in copyright litigation. We have Tusha Malhotra. She's a partner at Anand & Anand, an experienced IP litigator with expertise in patent, trademark, and arbitration. She has represented leading companies like Novartis, Merck, and Mattel in landmark cases, including the Novartis case on Section 3D. Today, Tusha will take us through the latest advancement and controversies in patent litigation. IP litigation has been witnessing some exciting development in the last few years due to the technological advancement and growing global economy. Each of these speakers brings a wealth of knowledge and experience in their respective field, and together we aim to provide a complete overview on recent developments in IP litigation. Before I invite the speakers, let me take this opportunity to touch upon certain prominent IP developments. One of the biggest shifts which we have seen in recent time in IP litigation is the creation of intellectual property divisions. After the abolishment of IPAB in 2021, the High Courts took on a more direct role in handling IP litigation. Delhi High Court was the first one to have its own IPD, which became operational in 2022. In the first year itself, it handled more than 1,000 cases and set a new benchmark for handling IP litigation efficiently. Other high courts have also joined in, with the Madras High Court setting up in its IPD, I think, in 2023, and Calcutta High Court following in 2024. Even, Himachal Pradesh High Court had its own IP division, which means that handling of IP disputes is not limited to metros specifically. So these divisions help us not only to improve the speed of dispute resolution, but also ensure that legal and technical strategy expertise is included and applied in all IP cases. Another trend which we have noticed is the protection of personality rights. The way we protect the rights of the celebrities have also gone through a lot of changes. Whenever celebrities like Anil Kapoor, there have been few cases on that respect. Anil Kapoor, Jackie Shroff, Telugu actor Vishnu, and all the famous singers, they have been protecting the personality rights, and these are the personality rights which have been protected against AI-based violation. So that's another one of the points which my fellow panelists would cover. Another important issue which has been clarified by the division bench of Delhi High Court is that when the trial court is satisfied on the rectification of a trademark, that there is a prima facie case, then the infringement proceeding against the defendant must be stayed. This was in an appeal against a single judge decision in Senna Herbal case, where the court had previously held that a litigation, the trademark litigation and the rectification proceeding could continue simultaneously. However, after this ruling, the procedure under Section 124 of the Trademarks Act has been clearly defined. In yet another important case of Sun Pharma, the Delhi High Court has held that the evidence in trademark opposition need to be filed within 2 months' time. That period is not extendable. Earlier in the 2003 rules, there was an extension provision which was available. Now that extension with the 2017 rules, that extension was taken away. However, there have been some conflicting decisions by IPAB, but with this ruling, now the applicant and the opponent would need to file their evidence within those strict timeline. The Toshiba trademark dispute is one for the history book. This 35-year-old long battle between Toshiba, the Japanese international company, and Toshiba Indian Appliances, the Indian entity, came to finally end in 2024. This was a unique decision which came where there was no interim injunction in the beginning, but after 45 years of defendant's use of a trademark, the Delhi High Court decided against the defendant, and the defendant was asked to stop the use of its trademark after 45 years of wrong. So this made a very unique decision. Now, with this, I would like to invite comments from our speakers on what have been the recent trends in patents, trademark, and copyright litigation. So I would start with Lakshmi, who would focus on trademarks. Lakshmi.
Thank you, Umesh. Good afternoon, everyone. Picking up from what Umesh has just presented before you, that is the capsule view of IP litigation as it stands with the trends in the last year. So if you look at the trademark application filings in India, which is kind of the precursor to the trend in trademark litigation, which is what I'm going to be speaking on, the number of trademark application filings have increased from 1,94,000 odd in 2014-15 to almost 4 lakh applications in 2022. So what you see is the growing brand consciousness among businesses, which again is reflected in the growing awareness towards defending your trademark, protecting it through litigation, and which in turn makes the court go all out to ensure that the rights of the righteous party are protected. So if you look at the march of law regarding trademark litigation, we have the old Anglo-American case of Sanforth, where in the 1850s, this is considered the first case in Anglo-American law, where a cloth merchant sued another cloth merchant, saying that how can you use my mark on your cloth? And coming to India, we have the case of the National Sewing Thread Company versus James Chadwick, which was the first trademark litigation, the first judgment that was pronounced by the Honorable Supreme Court just 4 months after the court was constituted in India. From those origins, we have come a long way. And if you look at the most recent trends in trademark litigation in India, one very recent trend that we have seen last year is the increase in the litigation that is filed by NPEs, that is non-practicing entities. This reminds me of a story. This is a story from the Hitopadesha. See, there was a village, and there was an orchard, a fruit orchard that the villagers used to maintain next to the village. They used to grow all kinds of fruit trees there, lots of fruits. They used to harvest the fruit. So one day, some of the villagers were walking that way at dusk, and they heard ringing of a bell and evil cackling laugh, not the tinkling laugh, but a cackling laugh. And They were at a loss and they thought, okay, evil spirits, we should not walk this way hereafter, especially at dusk. And the villagers stopped going to the orchard at all because of that. It continued every day. They observed and it was there every day at dusk. The ringing of the bell and laughter. And all of them stopped going. They didn't want the fruits on the orchard, even though they had gone to so much of effort to grow those trees, nurture them. They were not in a position to pluck those fruits. Then one brave woman of the village said, see, I do not think it's an evil spirit. Please let me go and check. And then she goes and checks. And she finds that it is a group of monkeys who have somehow got hold of a bell that they found somewhere. And they roam around the entire day. Towards dusk, they are totally tired and they need some entertainment. One of them starts ringing the bell and the others start hooting on hearing the noise. This is what was happening. So now, why this story now? Coming back to the non-practicing entities in litigation, I'm talking about trademark trolls or patent trolls. There are trolls that we see in all litigation. So there has been a proliferation of cases that have been filed by them. And the courts have gone all out to combat these cases. Other trends that we have seen are the declaration of a lot of marks as well-known marks by the honorable courts, especially the Delhi High Court. They have declared Haldiram, IKEA. They have ratified Amul once again as a well-known mark and its status. They have also declared Mochi as a well-known mark. We have also seen the use of, the unauthorized use of trademarks by social media influencers and the hazards that it creates and the trademark disputes that stem out of it. Personality rights, as Omesh mentioned, is also a major area that the court has taken up, including the personality of a cardiovascular surgeon, Dr. Devi Shetty, and also Jackie Shroff, Anil Kapoor. So these are some of the latest trends that we have seen in the last year regarding trademark litigation. And the court has also been very strong regarding anti-counterfeiting measures, regarding especially luxury brands like Louis Vuitton. It has also encouraged Kia-Timet actions, which the basis in India was laid down by the Honorable Supreme Court in the Kuldeep Singh case. It basically says that you can take action even though there is no visible damage if you apprehend the danger of infringement. So my grandfather was a farmer. When it was time for cultivation, the crops grow, and when it is the time to reap, he knows that today is the day that you should reap the crops. And if we, the small children at that time, ask him, how do you know that the good day is today? He would say, I can feel it in my bones, that today is the day. So same stands for Kia-Timet actions also. Obviously, I cannot tell the judge that I'm taking action against this person because I feel it in my bones that he's going to infringe my mark. No, I cannot do that. But then I can also show the bench certain things to warrant my asking for a Kia-Timet action from the court. So I can show that there have been advertisements from them, which show that the product may come into the market at any point of time. I can also show marketing efforts by them being taken in the industry. So I can say that, see, the product may infringe upon my trademark at any point of time, bearing the infringing brand. So kindly give me relief. These are things that I can show the court. And there has also been an increased leaning of the court to giving relief in case of matters that are concerning public health. For example, the Delhi High Court has highlighted public health and consumer protection concerns in the trademark dispute between Viagra and Vigora. Similarly, in the case of Campa versus Jampa that dealt with juices, fruit juices. Even there, the court very categorically stated that when there is consumer confusion, it is pertinent to grant immediate relief. So these are some of the recent trends in trademark litigations that we have seen over the years.
Now I would request Udita to share thoughts on copyright litigation.
Good morning, everyone. Could I please have the PowerPoint? while they are putting the PowerPoint, it's a welcome change coming to Bombay with the cold in Delhi. It's nice and pleasant in Bombay. It's number 1. Yes. Okay. So just to start with the trends, the first is piracy. And you know, there is the cost of piracy, in fact, for Indian theaters and OTT owners. In 2023, the piracy economy in India was around 224 billion Indian rupees. Of this, if you see OTT platforms were around 87 billion rupees, theaters, loss to theaters was around 137 billion rupees. Now, most of this is through illegal streaming platforms. That's around 63% is through illegal streaming platforms, and which is followed by OTT content. Now, this infographic is from a very aptly named report, the ROB report, which was by the Ernst & Young and IAMAI, that's the Internet Mobile Association of India, which was conducted in October 2024. They did a study and came up with this report. So coming to what courts have done, what kind of remedies that the courts have come up with to deal with piracy. First is a very famous decision by Justice Manmohan, who's now in the Supreme Court. This is the decision, the UTV case. It's dynamic injunctions. Basically, this is against rogue websites. And rogue websites are basically anonymous websites which take a great deal of effort to remain anonymous to avoid liabilities. So this is a case where they laid down qualitative tests to identify what rogue websites were, or in other words, flagrantly infringing online location fuels. Now, the good thing about this test is that it's not quantitative, but qualitative. It will look at flagrancy of infringement by the websites, masking, have the registrant details been masked, whether there is indexing or categorization of the infringing content, where the volume of traffic that the website gets, whether there has been inaction in spite of takedown notices. So once they identify a rogue website, the court has and grants an injunction. What the interesting thing is, it's a dynamic injunction. So if the right owner comes across alphanumeric or redirect or mirror images, like Hydra-headed websites offering the similar content, they can go back to the joint registrars, who are administrative officers at the High Court, and request for the injunction to also cover these Hydra-headed websites or avatars of the rogue websites. Not only URLs, but the entire websites can be blocked. Now, this particular injunction was granted in 2019, which has been extended by various judgments of the High Court, including Warner Brothers and Disney cases, where it says that you don't have to go to the joint registrar. At the very instant the injunction which is passed is qua rogue websites and its various avatars. So you have alphanumeric or mirror or redirect websites. And interestingly, also directions are given to the DOT and Ministry of Electronics and Information Technology to block these rogue websites as such. The next interesting injunction is a dynamic plus injunction. This was in the case of Universal versus Dot Movies Baby in August 2023 by Justice Pratibha Singh. And here, you know, there's a very different point of view where it's dynamic not only qua the defendants, but also qua the plaintiffs. So it gives injunction qua the future works that the plaintiff might come up with. We have a different timing. So, yeah. Right, we have just internally decided on that. Yeah, all right. Now, these are, therefore, it's an ex ante instead of ex post. The other possible remedy which Canada has looked at is for live sports events where you have real-time site blocking orders. In such a case, what actually happens is while the event is going on, the ISPs have been directed to block any infringing website or any infringing content which comes up automatically. So what it basically envisages is the plaintiffs appointing an agent who notifies ISPs of such infringing websites immediately on a real-time basis. These ISPs bring down the infringing websites or pirated content immediately. That's again within 30 minutes of them informing. And this they do every half an hour till the event continues. The other thing is that to ensure that it is balanced, the plaintiffs can indemnify the ISPs to a reasonable cost of up to $50,000. Now, the next interesting aspect is what is happening on social media. So there are some statistics where in 2022, India had 73 billion social media influencers. They're second only to the US. 69% of consumers consider Instagram as the most authentic platform to find recommendations. So you have a lot of marketing that happens through social media. This is a case of Manish Malhotra that we handled, where basically the infringers, or there are many infringers who were offering the same dress, in fact, showing the same photograph as was available on Mr. Manish Malhotra's website, and getting orders, asking for orders to make the same dresses. So we got an injunction, not only so the copyright in these suits were asserted for the garments itself, because these were limited edition garments, these were bespoke garments made for the celebrities, and also the photographs and images that were present on the websites. Now this is again something that for which the copyright was held by the plaintiff. The defendants were restrained from dealing in, first of all, are asked to pull down all these infringing photographs. Number two, they were also stopped from reproducing or copying the garment design. And there was an order, then the order that was granted, we sent to Instagram to pull down those links. An interesting thing that this particular case comes up with, or deriving from that, here there was a limited edition garment, but there can be fashion designers who mass produce their products. So you have a thing under the Copyright Act of Section 15(2), which basically says that the copyright protection for an article which is capable of being registered under the Designs Act will cease as soon as the article to which the artistic work is applied is reproduced more than 50 times by an industrial process. Now, this has a lot of effects on artisans, designers like fashion designers, jewelry designers, you have toy manufacturers, handicrafts, and basically we've also moved a writ which is presently pending, challenging the constitutionality of this because of the very nature of the artist community. They are not people who have the financial resources to go and protect every design that they come up with. They also do not seek legal advice thinking it's expensive. The other thing is prior publication, because the design law says that anything which is prior published is not subject matter of design protection, cannot be protected under design. So you have a question of prior publication because many of these designers, they have events, they have conventions where they go and advertise their work. So they little realizing that they would then lose the design protection if they apply for the design after that. Now, what we have sought in this writ are basically two things. Number one is that at least, instead of no protection, because what actually happens is you're not protected under design because you're not applied for a design registration. You are not protected under copyright because you made more than 50 copies. So what actually happens is you don't get any copyright or any protection. So what we have sought, or one of the solutions that we say may be possible, is that you increase the time, at least give them 15 years in case of such designs, which is the same kind of protection that is protected given under the Designs Act. Or you increase the number of 50, because 50 was very arbitrarily provided in 1955 from a UK copyright report. So you increase that to something, a more feasible number. So this is something which is an issue which is pending right now before the Delhi High Court. We are passionately, and especially Mr. Anand's leading us on that, and we are passionately trying to see how we can come up with a solution for that. The next is the idea-expression dichotomy and the merger doctrine. So what actually happens in social media, you have a lot of stories, these are storytelling platforms. So there was a case which was filed by the Humans of Bombay Stories versus Peoples of India. So here, what they sought to protect was the entire thing of running a storytelling platform, the manner of running a storytelling platform. Now, the court also is a very old principle of idea expression dichotomy is that ideas cannot be protected. Is the expression that the ideas are expressed with, that is what is subject matter of protection. Now, another thing is a merger doctrine that basically says that if your idea is capable of being expressed in only a very limited number of ways, you can't protect that. So in this judgment, the court basically says that there can be no protection for the manner of running a storytelling platform. What can be protected are the proprietary photographs. If there are some proprietary photographs, some proprietary videos, or some literary content that the platform itself has developed, that can be protected, but not anything else, not something that is in the public domain.
Udita, I think because of the time constraint.
Okay, all right. I'll just very quickly go through. This is Ulta Chashma. This is a copyright on character. Characters, basically, there are two tests. I'm not going to get into that. But this particular TV series was more than 4,000 episodes, and it's been running in India since July of 2008. We actually protected the characters of this. And the basic thing which helped us is that each of these characters were protected by copyright registration. So that's something that producers should look at, is applying for copyright registrations where they delineate the characteristics of the character and protect it. Just very quick, there are other panels which are going to discuss this, but there are basically three issues. Authorship, as the previous panel also discussed. And then there is whether the output infringes the copyright. Now, whether the output infringes copyright is basically whether the output, if the output is transformative and there's no substantial similarity, then you can have, then it's out of being infringed, right? It's out of being stopped. But the more difficult issue is the training data that's being used. Now, there is a case that Dr. Diwan also mentioned. Dr. Mohan Diwan mentioned, that's the ANI media case versus OpenAI. Here, the issue basically is the OpenAI has basically said that we have the option of opting out. But the question is whether that's still fair, because when the AI tool was developed, it had unrestricted access to all data, even copyright data. Now, if it has come out now with an intelligent system, which is intelligent because of the unrestricted access it had, whether that is fair or not. So these are issues that are still pending. Then you have as just one personality rights, that's it last. So we have famous actors whose personality rights have been protected. We have Anil Kapoor, who's the first case. He in fact was featured in Times 100 Most Influential People Fighting Against AI Misuse. There's Jackie Shroff, Arijit Singh, his songs were being used, means AI tools were used to develop songs in his voice. Very recently, there have been celebrity doctors, Dr. Shetty and Dr. Trehan. Dr. Trehan, in fact, got an interim injunction from deepfake videos only very recently on the 8th of Jan. That's it. Thank you so much.
Thank you, Udita. I now would request Tusha to share her thoughts on patent trends. And I would request, Tusha to be covering her PPT so that I don't know if we may have a time for another question and answer round, but I would request to cover your PPT in limited time.
We won't minimize your role, don't worry. Good afternoon, everybody, and thanks, Umesh, for the introduction that you all gave us, the Power Packed Women panel. rather young and dynamic. Diversity at Anand and Anand, that is what we are representing today. So to start with, I'm going to keep it short. This morning at the breakfast table, we, 4 of us, were having together and we were discussing is the problem with the litigators when they start, they don't stop. I'm going to practice contrary to that today. Can you please put up the presentation? Okay. So keeping up with what I promised to myself to keep it short, I'm going to skip this slide, although it gives me immense pleasure to present this slide. Skipping it because it has been presented, the data at least has been presented twice since morning as to where India was positioned in the WIPO 2024 report, and it's very momentous for all us Indians and especially IP practitioners. This is what we do in and out every day to bring the law up and bring, which we also see today is having a very, very immense economic and financial implication on our ever-growing economy. So skipping that, but still taking pride in it, I would just mention before we get into the court rulings, because this panel is mostly focused on what the courts have done in 2024. I would want to mention at least 2 things before we get into it. One is it's important to make a mention for the patent amendment rules which have come out in 2024, which talks about reduction of timelines and speeding up the grant of patents. So that's one important thing that has happened. In addition to that, and especially in the IP ecosystem, where we see most of the inventors complain about that there are pre-grant oppositions which keep coming in and that delays the grant of patent. One very important development which has happened in the patent amendment rules is emphasis has been laid on a prima facie view of the controller or consideration of the pre-grant opposition before proceedings are started on that. To start with, whether the pre-grant proceedings should even be taken up. So that's very important. Going up with how the country has been going on with its economic and financial policies, there's been a development of introduction, although this happened in 23, but we felt some impact in 24 of the Jan Vishwas Act, which actually decriminalized a lot of provisions in the IP statutes, basically for ease of living and doing business in India. Now let's go on to what the court's been doing in 2024. The way I propose to address this, I've structured it in 3 different heads. First head is the courts have been really busy doing jurisprudential advancements in the SEPs or telecom sector, I would rather say that. We saw a lot of progressive orders coming, at least on the financial part of aspect of the SAP orders, the telecom jurisprudence, which is actually the desired output of that aspect. So the second is, what are the challenges the courts have addressed in the pharmaceutical sector? The patents and the problems with respect to patentability. And the third, with the abolishment of IPAB, the court has taken a very, very active role in providing legal interpretations for the IP office and streamlining the processes before the IP offices. So that's how we broadly cover. Umesh, you want to address your quick questions so that we can...
I don't know how much time we have left with, but I have few questions from each of you. So, there have been a lot of talk about SEP litigation and pharma's litigation, specifically on patent side. What do you think about, and what do you see that in future, what's going to happen, and what has been the trend on SEP and pharma litigation?
There's only one microphone's working. So can we put the presentation back on? So while the presentation is being brought on, there's one development which is very interesting from last year is, especially in the realm of SEP patent domain, the court undertook a very important query as the SEP domain, does it envisage anti-competitive practices? Whether it is anti-competitive for an SEP owner to offer licenses at its own terms and compel people to compel other companies to take licenses at its own terms, although they may be labeled FRAND. So that the anti-competitive part was actually gone into by the court, the Delhi High Court. And the court said it's pretty clear. Patents Act is a specific statute which will determine the processing or anything which is under the purview of Patents Act. Anti-competitive questions do not come up in that. Patents Act is the only guidebook for SCP patents and the licensing provisions, and there's enough in the Patents Act which provides defenses, or rather ways out for people or for companies which say that that SEP holder is violating or is abusing its position. So it doesn't have to be a competition inquiry, it is a patent inquiry which will sustain as a patent inquiry. The other thing, in the telecom patents, what we've seen is very encouraging. I'm seeking both on SEP side and the implementation side. What's been very encouraging is although it may be granted globally, India saw a trend-setting case towards the end of 2023, which started granting pro tem orders in SAP litigation, which basically meant that during the pendency of the litigation, a guarantee of sorts, a money guarantee of sorts should be furnished so that the patentee is well covered at the end of the case if the defendant is found infringing. This was taken further, a step further was taken in 2024 in the Interdigital versus Oppo case, where the court said the bank guarantees, in that case was bank guarantee, has to be made in India. It's not that there are parallel proceedings going on between the same plaintiff and defendant in different jurisdictions. And in those jurisdictions, if at one of the jurisdictions a parent guarantee is given, is not deemed enough, it's foreign banks taking care of it. So to protect the patentee, specifically in the lawsuit which is present before the court, the bank guarantee has to be furnished in India. These are where we start with pro tem, and it went even further, which was very welcoming, how court dealt with financial and damages, the remedies in telecom patents. So there are two things that the court did. There are two developments last year. The first one came in the SAP case, in an SAP case, and the second one came in an implementation case. Court took two different approaches in both the cases. The first case, which is the SAP case, the court calculated damages which were equal to the lost royalties on net selling end price of the device. So it's not the component. The court took into factor that end selling device would be the measure of computing royalties of SAP portfolio, which is applicable to that, and granted damages to the tune of 244 crores. In the other one, which was the implementation patent, one interesting thing to note there is that the defendant stopped appearing during the proceedings. So in a sense, the court had to take the proceedings on whatever was available, and at an ex parte level, level at the final stage, and yet went ahead and granted damages to the patentee. In this case, the damages were calculated to be the loss of profits or sales of the patentee. It was equated with loss of sales and of the patentee, and granted damages to the tune of $26 million or so. So this is how the courts have kept busy, at least on the telecom patent side. Very welcoming, very welcoming developments, and that's what 2024 looked like on telecom side.
Thank you, all of you. Now, before we conclude, I would want to hear from you that what do you think about the future IP litigation? What are the trends in that respect? What do you expect in next 5 years as far as the IP litigation or IP enforcements are concerned? Maybe we can start with Lakshmi and then.
We have this beautiful concept in Jainism called Anekantvad, which is truth is multifaceted. It also has its roots in Hinduism, where we say that Ekam Sat, there is only one truth. Vibro Dvade Vadanti. People see it as multifaceted. So there is not just one truth, there are various truths. Sometimes, many a time, in trademark disputes, there are situations where there are parties, both of whom, have rights, and then the court has gently guided the parties towards mediation. I think that trend we may see increasing as the years go by. One such matter that recently happened is Tesla versus Tesla Power. It is the first trademark matter that is filed by Tesla in India, and the matter is currently in mediation. The courts have directed for mediation. Similarly, the courts have been very active, as my co-panelists have mentioned, regarding domain squatting. And there have been various judgments that have come out in the past year, including judgments blocking various websites, the Dream11 website, also websites where first copy products have been sold of luxury brands. So the courts have endeavored to maintain a Nash equilibrium regarding these aspects where the infringers have not been able to gain any strategic advantage over the rightful owners of the trademarks. This is a very good trend, and the courts have been able to maintain that equilibrium and make sure that there are no rogue websites in place where there is an infringement of trademarks or any other IP for that matter. The third thing that, the third increasing trend that we will see in the coming days is where the courts widen the horizons of the existing legal boundaries to examine how they can protect unconventional trademarks. That is sound marks, smell marks, especially smell marks. The recent case is Coties, where the court endeavored to protect the mark. But then again, when you say you have to submit a graphical representation of the mark for its protection, the smell may be different for different people. So how exactly do you submit that remains a question mark. It's like the story of 6 blind men touching the elephant, and each of them perceive it as different. So when you describe a perfume as floral, it may not seem floral to the other person. It may seem woody. So that is one thing. How exactly do you protect a smell mark? Sound mark started in India with the Yahoo Yodel, and protection has continued. But smell marks is still a gray area, and jurisprudence will widen in these areas in the coming days. So these are the trends that I see going forward. There will be a lot of panels post this that touch on AI, so I will not be commenting on that. But AI has definitely changed things everywhere, and it is there to stay. And courts will have to look at how exactly they combat AI-made trademarks and AI-generated content that infringes on trade dresses of companies in the days to come.
Very cleverly, Umesh skipped half my section. So although I'm going to address your question, I'm going to still go back as to what progress was made, and continuing from there, what progress is going to be made. Can we put my slideshow back on, please? So I did speak about the telecom sector. There's a lot of interesting developments that have happened in the pharmaceutical sector, which has been active for almost a decade now. But the court's taking very progressive approach towards it. So we saw at least we saw at least 2-3 very welcoming decisions coming out. One was wife versus corona remedies. It basically spoke about the challenge that the court was facing, or the law that court was interpreting, or argument that the court was addressing, defendant's argument, which was that if there is a product by process claim and the process is different, the claim isn't infringed. The court gave a very, very good finding on that and clarified the law, saying it went all the way up to the division bench of the Delhi High Court and said that there are certain molecules which have to be structurally, it cannot be structurally defined only, it may have to take aid of a process to come to give a proper definition or a description of that. The court accepted that. Accepted that description and went on to hold that patent protection in product by process claims will extend to novel and inventive product regardless of the process used to attain it. So this is one. The other thing that the court is doing is right now is seized with a difficult question of biosimilars, which the court is presently hearing. The challenge that comes in biosimilars, which biologics and biosimilars, unlike other small molecules, these are large molecules, and on proving the infringement, maybe 2 batches may not even be the same. So the question how to prove infringement is what the court is seized of. And one thing which is one guidance that we have comes from the US, where the court said preponderance of evidence, but I'm pretty sure that Delhi High Court, which is seized of this matter, is going to adopt all principles and is going to lay down the law in 25, at least starting out on this jurisprudence. So this for certain commenced in 24 and is going to go on in 25. Another thing in pharmaceutical patents, the court gave very definitive and clear guidance on claim construction as to how it cannot be read in, limitations can't just be read into it. And this is how we are seeing there were improvements, there were discussions on 3D, section 3D, section 3K, 3B. Everything's in my slideshow since I am under an obligation to conclude early. Please do reach out to either of us and we'll be happy to share our slideshows with you. But just, I wanted to take 1 second. There was a question raised in the previous panel by Dr. Ganguly that court that there is no definition of technical effect. May not be, but the courts are doing their bit in assessing each situation and determining what amounts to technical effect. So we're making progress, we are getting there. We may not have a broad guidance to say so, which could be clearly implemented, but the courts are determining what amounts to technical effect. And one of the cases, court even went on to say that if computational ability is enhanced, that amounts to technical effect. So all these cases are there in the slideshows. I will share it with the organizer, and everybody may have the access to it. So this is what has happened in 24, continuing in 25. Of course, once again, like my co-panelist said, I'm not going to talk about AI-related inventions because there are panels just constructed or just doing the discussion around it. But we will see much happening in that sector too. Thank you.
Sorry for overextending our stay, but the Indian courts have been very busy, so the recent trends we've struggled to cover as many as we can. Thank you so much.
Thank you, everyone. So before we conclude, I think we should be having 1 or 2 questions. I think that's the time limit we have. So if anyone has any questions, they can really ask.
So that one, the quantification came with the number of units sold and the FRAND determination of the royalty rates. The court did simple multiplication, came to the answer. That loss of profits for the patentee was considered or deemed to be the gains made by the defendant. So that was the evidence that the plaintiff patentee led that they were making such progress. With the entry of the defendants, the numbers have gone down. Mr. Anand has, yes.
See, another trend, not a trend, the standard practice that we see is that companies protect their trademarks, but they ignore their trade dresses. So many a time there is dispute around this. They have the brand protected, but then we find infringers in the market who infringe on the trade dress, and they do not have a protection for that. So companies need to be proactive, do defensive registrations that can protect all the trade dresses, all variations of their name. For example, Delhi High Court advanced the jurisprudence on typo squatting. They gave the infringement, they gave an interim injunction to Google regarding infringement on GOOCLE, GEOGLE, all those typo squatting. So filing for variations of the main brand, filing for all the sub-brands, filing all the trade dresses, these are some gaps that companies will come across in their IP audit and they will need to address in order to build a strong brand portfolio in which they have a stronger case in case the matter comes to litigation.
Thank you, Lakshmi, and thank you, Tusha, and thanks, Udita. With this, we conclude. We are here for 2 days. If anyone has any questions, we are free to answer. Thanks a lot.
Thank you very much for that brilliant panel discussion covering all the recent updates in the Indian courts. So I'd like to request all of you to please remain on stage. I'd like to call upon Mr. Praveen Anand, Managing Partner, Anand & Anand, to kindly felicitate our panelists. First up, Mr. Umesh Puri, Partner in Trademarks, Anand & Anand. Next, Ms. Lakshmi Devi Somnath, Partner in Litigation and Strategy. Ms. Udita M. Patro, Partner in Trademarks. Lastly, Ms. Tusha Malhotra, experienced IP litigator at Anand & Anand. Thank you all for being part of this wonderful discussion.